course it is. I'm recording it. Big group today. As always, we will give people a couple of minutes to jump on the call. And as always, since the beginning of the pandemic, our theme music is Zoom by the Commodores. The legendary and fabulous Commodores, of course, featuring Lionel Richie from my old hometown of Tuskegee, Alabama. The Commodores put out Zoom in 1977, and I like to say I wish I'd taken their advice and bought Zoom stock right before the epidemic took place. About 1 minute, maybe a little less. Well, what a joy to see so many familiar names and a few I don't know. Glad you've chosen to join us for our monthly webinar. We've been doing them for 3 or 4 years now. And we have a hot and timely topic, which I'm so glad you joined because I think you need to know about. Hello, I'm John Miller, and I am the founding and senior attorney at Rock Solid Law and Title, founded here in Ponte Vedra in 1991. We practice in 3 areas, and I would say that today's topic touches all 3. Of course, we close real estate professionally and on time. We serve Florida families, and actually through our collaborative, families in other places through values-based estate planning and asset protection. I mentioned that today because we're going to talk a little bit about that. And finally, what we're really here to talk about today is we love representing entrepreneurial small business owners. And there is a new law coming right down the pike. It wasn't passed recently, but it goes into effect on January 1st, and you need to know about it. Many of these webinars I am able to teach just from my base knowledge, but this is a subject that is new to all of us. And so I'm going to be reading a lot of notes today, so the readers go on. I will let you know that there is a question panel at the bottom. It's about right there. And if you have a question, I'll try to save some time at the end to answer it. If you have a question that is personally fact specific and you don't wish to share it on an open webinar, please email it to questions, that's plural with an S on the end of the word question, at rocksolidlaw.com, and we'll get back to you. Additionally, I'll go ahead and let you know this is a hot topic now. Hang on to the end. I'm gonna make an offer to meet with any of you that are on this call to discuss personally any of the implications that that might be important for you, or maybe a customer or client of yours that needs to do some planning. I think it's safe to say that I've practiced law since the mid 80s, and most of my clients are concerned with keeping their ownership of assets private, including their ownership of companies. often multiple companies. There are many good reasons for this. One is just to stay out of the sight of busybodies. But if they can't find it, they can't collect it. So it's a great asset protection avenue. And of course, there are just multiple other reasons. Some people are just private. A lot of the privacy laws in Florida have grown up around the celebrities that enjoy, as we do, living in our gorgeous state, and who don't want everybody to just be able to hop online and find out what it is they have. So small limited liability companies will soon have to disclose to the federal government details of their ultimate ownership. Thanks to anti-money laundering legislation, which was passed in 2021 in the National Defense Authorization Act. As so often, what we're talking about today has really nothing to do with defense, but it was appended to that bill. So the National Defense Authorization Act of 2021 was passed while President Trump was still president, but does not become effective until January 1 coming, right? Next January 1, 2024. It includes the Corporate Transparency Act, and that's what we're here to talk about today, which aims to curb nefarious activities by establishing reporting requirements for the owners of most corporations and LLCs. And as we know, owners of corporations have been more easily discoverable, and we've used LLCs for anonymity and privacy in our practice and in the practice general. The anonymity of beneficial ownership of corporate and LLC interests has been a feature of small business governance for time immemorial. So if you think about it, this is a big change. This is not a small little law that's making a tiny difference. This is something that has been useful for a long, long time. Before we get off the call, I'm going to tell you how you can extend that privacy for an additional year. I always say, and I see my friend on the line today, that there are two sets of laws in this country, and one is for the informed and the other for the uninformed. At the end of this call, you will be informed about what you can do to keep privacy for an additional 365 days. So that anonymity of ownership has vexed federal, state, and local regulators, as well as private litigants trying to get to the bottom of the ownership puzzle, right? Which is exactly what we were trying to do. And has been a source of comfort to owners who want, for whatever motivations, to remain anonymous. This law will make asset protection more difficult. Owners of existing and future business entities and the professional firms that form and administer them should get ready for this new law. The disclosure requirements will apply to only certain smaller entities, not just limited liability companies, of the types that Congress thought created the maximum potential for use in money laundering and other illegal activities. I have an opinion on that. I'll share it in a minute. The inclusions and exclusions are intricate and extensive. This is not, I stated, a Holiday Inn Express do-it-yourself stuff. You need to have an expert help you through this maze. They mean that many ordinary limited liability companies formed for real estate investments will need to report their ownership. Got that? The LLCs that we form to hold entities, real property in an entity privately with anonymity is no longer going to be available. We're working on some strategies. Once a company is subject to the reporting requirements, it's got to disclose its, quote, beneficial owners. And anyone who exercises, quote, substantial control, end quote, over the company or owns or controls more than 25% of its equity is a beneficial owner. The law requires the tracing of ownership to actual people, not just more companies. So you lose that thing where you can have a company own a company and they can't figure out who owns the first company or the second one, right? Those actual people have to disclose their name, date of birth, address, and a government-issued identification number. driver's license, passport, or they're supposed to be creating a new identifier for this purpose. Who knows what that's going to be? Get this, when a third party, such as a law firm, submits this information for a company, whoever submits it must provide the same information about themselves. So lawyers are going to have to report, and other people who are creating LLCs, whether lawyers or not, there's a whole discussion around that, are also going to have to disclose all of that information: name, date of birth, driver's license, or some other government ID number. Fortunately, at 63 years old, I'm pretty clean and I don't have a problem with that. But I imagine there are a lot of people that are not going to want to do that. The new requirements will take effect at the beginning of 2024. I said that. Catch this. Everybody who's not listening, listen now. Pre-existing companies will then have 1 year to make their disclosures. New companies will have to do it immediately. All right, got that? If you have a company existing this year, formed on or before December 31, 2023, you don't have to disclose until a year later. If you form it the next day or the next week into 2024, you must disclose immediately. Therefore, we can at least protect 1 year of privacy. My ongoing theory is that within that year, brilliant attorneys around the country will establish some strategies for continuing to keep ownership private. I've got one rolling around my brain, and some of you have talked to me about that before. I believe I presented it to the Jacksonville business professionals. That may be helpful. So immediately, any new company formed next year must comply unless there's an exception for it. We're going to get to those exceptions in a second. Little foreshadowing. It's not most of us. If the beneficial ownership of a company changes, then the legislation requires an update within a year, maybe sooner. We'll see what the rules are on that. Congress wants all these filings to be coordinated with the state-by-state filings already required. You know, your annual report here in Florida. So failure to file could trigger substantial penalties, such as $500 a day or 2 years in federal prison. I pity the poor fool who goes to federal prison for violating this law, but with exceptions for some errors that are corrected quickly. So a simple mistake can be quickly corrected. So, hey, lawyers on the line, the penalties even seem to apply to law firm employees who make the filings for their clients. That's you and me. This may concern law firms' risk management committees who may decide to have the clients do the filings themselves. I would certainly think it would frighten other professionals who are forming entities as a service for their clients and may want to reconsider that. All right. The legislation says the new disclosures will be used only for law enforcement, tax administration, and similar purposes, and must remain confidential. What is it? What's the line? You guys probably remember. Hi, I'm from the government and I'm here to help. Here, take all of my private information and I trust you to keep it confidential. The government's new organized collection of information is certain to attract deference from all kinds of people, starting with divorce lawyers, private investigators, reporters, and activists looking for people to harass. It would take a simple amendment of the law to allow access for everybody, such as any, quote, legitimate purpose. So thousands, maybe millions of companies will now have a new legal requirement imposed upon them to help the government catch some bad guys. But you know what? Those bad guys will need to figure out a new way to do business without disclosing their entities to the federal government. That may make life a little harder for them. They're pretty good at that sort of thing anyway, aren't they? So probably catching a little edginess. I think this is overreaching by our government, but it doesn't seem to be going away. All right. So the ownership of closely held companies and LLCs has been a black hole in terms of registration and our ability to keep it quiet. They're going to have to disclose. The disclosure will be to the Financial Crimes Enforcement Network, FinCEN for short, and within 30 days of filing. Again, the reason for the new law is stated as being to crack down on illicit finance and enhance transparency, stop criminal actors, including oligarchs, kleptocrats, drug traffickers, human traffickers, and those who would use anonymous shell companies to hide their illicit proceeds. They've issued a rule. I have not reviewed the final rule at this point, but it looks like it's going to limit the access to federal agencies engaged in national security, intelligence, or law enforcement activities. So far, so good, right? State, local, and tribal law enforcement agencies with court authorization. That means a court can say that your local county mountie can have access to that information. Do you think that's rife for an opportunity of abuse? I don't know. I trust the court system, but that seems pretty difficult to me. Catch this. Financial institutions with customer due diligence requirements and regulators supervising them for compliance with such requirements. I'm telling you, every mortgage, every document with every bank is now going to give them permission to access this data bank because they all have due diligence and regulatory requirements. Foreign law enforcement agencies, great. Banana republics can get at your information. Prosecutors, judges, and other agencies that meet specific criteria. Treasury officers and employees under certain circumstances. So supposedly the general public will not have access to that information, but it seems pretty broad how far it's going to be shared. Yeah, we are no longer able to assure our clients of 100% anonymity of closely held entities, LLCs, and corporations. And it remains to be seen how that may change the way small business is regulated and acts. Okay, so I think that's pretty good overall. Here's the summary of what we talked about. If your company, exceptions, I told you, I promised you I'd talk about that. If your company employs more than 24 time, John, if your company employs more than 20 full-time employees in the US and has over 5 million annual gross sales in the US, the act does not apply. So who got exempted? Big business. Anybody shocked? Big business got exempted. But if you have a shell company or a subsidiary with less than 20 employees, then the act will apply. So there's going to be some delicate positioning as a result of this act. So for a long time, we've been one of the few jurisdictions which doesn't require this type of disclosure. I think that's as a result of our rugged individualism from the time we were founded as a nation. And Congress thinks that that's being abused, and so they created this act. I don't want to hammer points too many times, although they say if you're arguing to a jury, you litigators online, you got to say things 3 times for them to get it right. So, this article that I found said that it's defined broadly, but the exceptions will remove most U.S. companies with significant operations. But I really think small business falls outside of the exceptions. So my small business clients are going to have to file this information, I believe, by the end of January. We're going to look into that a little bit further. So You got to, again, disclose every beneficial owner. It can't just be one beneficial owner. And that captures not only equity holders, but senior management who might not hold an equity in the reporting company, right? So your general manager, your CFO, certainly, CEO, COO, all those people have to be included in the reporting requirement. So it's each person with significant responsibility to control, manage, or direct the company that is required to report. It thinks, this article states that it will include the president, vice presidents, treasurer, managing member, if it's member managed, or a general partner, if it's a limited partnership. So again, big companies get a get out of jail free card and a pass and don't have to comply. This onerous requirement falls squarely on small business, the heartbeat of the American economy, the entrepreneurs among us who keep our economy going strong. So again, it says it will not be made public, but I'm skeptical. It would just take one act of Congress to make it so public. And I'm sure all the lenders are going to get all the information. Should they? I don't know. If you want to borrow their money, that might be reasonable. But I think it is an onerous governmental layer of required disclosure. Certainly going to make our jobs in protecting assets more difficult. So, bottom line, as of January 1 next year, like, what's that, 7 weeks from now, every company filed will have to make these disclosures. There's got to be a form. I think there's one in draft. I don't believe it's been finally approved, but I'm not sure about that. So what's the opportunity? I always say, in every problem, there's an opportunity. The opportunity is, if you wish to maintain an extra year of anonymity, 365 days, 12 months, 52 weeks of nobody knowing who owns the company, it's incumbent on you to form new LLCs before the end of the year. Now, I know every Tom, Dick, and Harry can jump online at Sunbiz and form things. I would suggest to you that this would be a really bad time to be a do-it-yourselfer, because if you screw this up, there are huge penalties. So I would suggest to you that you need to meet with a business attorney and make sure you're doing this right, so you keep your privacy intact for an extra year. As I said before, anyone on this call wishing to talk about this, call our office or email us at questions@rocksolidlaw. Our office is 904-241-1113, and make an appointment before. I wrote down November and didn't write down what date. I never went back and filled it up. I need you to make that appointment on or before November 20th. That's fair. That gives you 10 days, right? And the reason I don't want to extend that is I think the year end's going to be crazy with this new law coming in. So if you'll get with me early, I'll waive the consultation fee, no charge to sit to me up to an hour. Either sit with me, we can do it on the phone, we can do a Zoom, whatever works best. And we can discuss the strategy that works best for you. If you are heavily into investing in real estate or other things, you may want to consider setting up a series of these entities to keep your privacy intact for an additional year. Now, the reason I think that year is important is I believe that smart lawyers and other people will get in gear during the coming year, when this has become a reality, and figure out additional strategies to protect us. I don't know what it's going to be yet. I have one idea, and I'm not sharing that on this call. I've told you before, if you want to find it, Rock Solid Law /webinars, you can find that one. And it's keeping real property private. That strategy is discussed there. So I'm not going to extend the November 20th date. I'm actually writing it down. And because I think that there's going to be a lot of people, you know, we love waiting to the last minute, and there's going to be a lot of people wanting this done in and at the end of December. And I'm pretty comfortable letting those people pay full price. So you guys have an opportunity here. I wrote in my notes, I'm making you an offer you shouldn't refuse. So want to meet and talk about this before the end of the year? I know make the appointment before November 20th. That will probably put us after the Thanksgiving holiday to meet, and we'll still have to get in gear quickly to get your strategy in place and effectuated before December 31st. All right, guys, that's the presentation for today. Big change in the law, right? And I want you guys to be aware of it. I want you to be able to talk about it with knowledge, and I want you to come talk to us about it if it can be helpful to you or your customers and clients. Must have been absolutely crystal clear today. I don't see a single question, which is awesome. If you have one, I know I've run up against our 30 minutes here today. If you have one, send it to me at questions, plural, at rocksolidlaw.com. My team will get me that question. We'll get you a response. I am so appreciative of you guys spending time with me today. I am John Miller, founding attorney, Rock Solid Law and Title in beautiful downtown Ponte Vedra Beach, Florida. Thanks, guys, for being with me. Have an amazing Veterans Day. And to the members of my family tree and all others who have served, I want to express my never-ending gratitude for your service. Thank you, veterans. Have a great one. Take care.